been noted when, I think maybe when he was in the other day, when you were here, Mike, there were some questions about the seizure, the forfeiture statute. I'm not sure whether we use both words or we've been saying seizure, but maybe the language is forfeiture.
It's both.
Okay. So maybe that's something to talk about, whether there's a distinction and so there's existing law that and we'll find out more about that, I guess, what can be seized under what circumstances, and then the idea, the way this is written, is that we would use that existing law to enable seizure of equipment for the crimes that are discussed here.
So I'm going to share my screen.
Okay. And are you pulling up something that we have?
It's just statute.
Statute.
Okay. So there is an existing seizure and forfeiture authority in Title 18 related to the seizure of illegal drugs. But before I start walking through that process and how it would be invoked for the equipment used in timber trespass or land improvement fraud, I want to be clear that seizure is a discretionary authority, both under existing law and underneath H614 as proposed. Law enforcement does not need to seize the equipment. They are just authorized to seize the equipment. So they don't believe seizure is necessary or it's too complicated, etc. They are not required to seize the equipment. And seizure is the taking of the possession of that material, that equipment. And forfeiture is the process by which your ownership right, if any, is forfeited. And then the state auctions it, and the proceeds are then distributed as directed by statute. So seizure is the taking it into possession by law enforcement. Forfeiture is a process by which the equipment or whatever is seized is determined to be subject to sale, and then it's then sold.
Representative Bryson.
And in the instance where someone else, like a bank, is the owner of the property, then it wouldn't be subject to sale.
It might be subject to sale, but then that lien holder has that priority in payment. They get paid their interest in that equipment. And we'll walk through all of that right now. So first you'll see that there is a subchapter related to forfeiture. It's called forfeiture, but it should be about seizure and forfeiture. The first section there, 4241, is the scope, what the section applies to, what the subchapter applies to. In your bill, this section is amended to include equipment that's used in the commission of land improvement fraud or timber trespass. So what it would be added would be 8 or 9 subdivisions there in sub A. So this would be property or an action where seizure and forfeiture could be exercised. Then you get to 4242. This is how seizure is initiated. So there were questions the last we went through the bill about what the process is, whether there's due process. That first subsection A in 4242 is process. The court may issue a request of the state to seize or secure property for which forfeiture is sought and to provide for its custody. That's the court's due process. And process for seizure of such property shall issue only upon a showing of probable cause that the property is subject to forfeiture. However, there is opportunity for law enforcement to seize property without that process, without that court order in sub A, when it's incident to an arrest with probable cause or a search under a valid search warrant, which they had to have probable cause to do for that valid search warrant. And the property is subject to seizure, has been subject or prior judgment, or the seizure is incident to a valid warrantless search. So generally, if law enforcement requests seizure, the court will order it. There is your due process. There are some opportunities for seizure without that. But if it's seized without process, you'll see that in 4242C, the state shall petition the court for a preliminary order or process order under subsection A. So even if you seize it without that initial court order, you've got to go to court to further authorize that seizure. So there is due process built into this seizure.
Representative O'Brien?
Thank you. Is all this rising to the level of criminal violation of statute, or is it still sort of partly civil violation and it rises to a?
So most of the seizure authority right now in Title 18 relates to to illegal drugs and the contraband related to that. But there is also property seized pursuant to 13 VSA section 364. That's animal cruelty. It is criminal animal cruelty. But so most of what's already in the seizure authority is for crimes. In 614, you're authorizing seizure in 3 instances: for the crime of land improvement, for the crime of timber trespass, or where there's a civil judgment for timber trespass that remains unpaid. You're authorizing a civil seizure for a civil violation that remains unpaid. And that is effectively, that's how civil judgments are enforced, especially in other states. If you have a civil judgment, you owe someone a certain amount of money and they're not paying, you can go to a court and ask for seizure of their assets, put a lien on their assets, et cetera, in order to secure your judgment. So that it's not some new or revolutionary authority here. It's something that's effectively used for civil judgments. So
Representative.
Mike, the reality is, with regard to seizure, as we've learned, a lot of these thieves are clever in many ways, but one of them is they may not own the equipment.
sure, we'll get to that in a minute. That's going to be addressed in a minute. Okay. So that takes you to forfeiture then, which is 4243. So an asset is subject to forfeiture if by judicial determination, it's one of those listed in 4241, or it's one of the assets seized under animal cruelty in 13 VSA 364. And if the person is convicted of the criminal offense, or a person enters into an agreement with the prosecutor to allow for the forfeiture. So remember, seizure is when you are subject to one of those listed properties that is subject to seizure, and you either have that court order or you have a valid warrant and search. Then you go to the court again to confirm your seizure. And then for forfeiture, you only forfeit that property if you've been convicted or you agree to forfeit that. The state bears the burden of proof by clear and convincing evidence, and clear and convincing evidence that it's more likely true than not that the property is the instrument of the alleged crime or violation. There's a bunch of basically procedural due process. Days, within 60 days from when seizure occurs, the state shall notify any owners, possessors, and lien holders of the property of the action if known. So every lien holder or other known owner is given notice of the potential forfeiture. And the state can extend that up to 90 days if it wants to. If that notice is not sent and no time extension to 90 days is granted, the law enforcement agency returns the property to the person they seized it from. So if they don't send out a notice that they are going to seek forfeiture of that seized property, or they don't extend that time frame from 60 to 90, they have to return the property to the person who they seized it from.
The they in this case is law enforcement.
Law enforcement, yes.
Yes.
How do they know, you know, the Skidder paid for Milton Cat and there's a lien on it? If the,
How do they-
the logger isn't forthcoming with that information.
Well, it is that there is a caveat on that notice if they know, if known or readily ascertainable. So for equipment like this, they probably will assume that there's some lien holder and they will probably look into that. Now there is this other provision down in 4244 where, well, there's two provisions here. A lien holder who has received notice of forfeiture may intervene as a party if the court finds that the lien holder has a valid good faith interest in the subject property that is not held through a straw purchase, trust, or otherwise for the actual benefit. So if there's basically fraud in the possession of that lien, then they're not potentially not going to acknowledge it. Or that the lien holder did not at any time have, and the lien holder has to not have any knowledge or reason to believe that the property was being or would be used in violation of the law. The court, upon forfeiture, orders compensation to the lien holder to the extent of the lien holder's interest. So if there is a lien holder, the lien holder gets paid unless that lien is somehow fraudulent, straw purchase, etc. Now, the question that Representative Lipsky was going to ask, the court shall not order the forfeiture of property if an owner, co-owner, or person who regularly uses the property other than the defendant shows by a preponderance of the evidence that the owner, co-owner, or regular user did not consent to or have any express or implied knowledge that the property was being or was intended to be used in a manner that was subject to the property to forfeiture, or that owner, co-owner, or regular user had no reasonable opportunity or capacity to prevent the defendant from using the property. So the good faith owner who loans that out to a harvester who commits timber theft or land improvement has a claim for the return of that property. If they loaned that equipment to the harvester with knowledge that that harvester was going to then commit land improvement or timber trespass, then they don't have the claim for return of that property.
To follow up on that, and I'm looking at Chris, Delia.
Don't, you can look at him, but don't.
Okay. There is, oh, for years, there's a thing called a UCC file, Universal
Commercial code.
Commercial Code, which most lenders, whether it's a banker or a manufacturer, will file this lien that until the debt has been paid off, that stays in place. Can you articulate how prevalent the UCC filings are, and does law enforcement automatically go to that register?
That really is a question for Chris. I don't even know how the UCC would apply to this equipment. So that's really a question.
We can,
Okay.
if Chris is still here afterwards, we can bring him back and, or you can talk to him offline, but,
Okay, thank you. I apologize.
So there's the hearing, that the owner or a lien holder has the opportunity to assert their interest. The lien holder will be paid if there is forfeiture ordered, and forfeiture does not need to be ordered. The court, again, has discretion to order forfeiture or return of the equipment. So it does not need to be ordered. The court has to issue a final order. They have to deliver that order to the state treasurer. I think the next major question or section you want to look at is 4246. When law enforcement seizes property, and shall ensure that the property is properly maintained. It shall be removed to an appropriate place for storage. Any money or security seized shall be deposited in interest-bearing accounts. It's not really an issue here. And then you get to the disposition of the property. When property is forfeited as ordered by the court and delivered to the state treasurer, not sooner than 90 days after the property is delivered, shall sell the property at public sale. The proceeds of the sale shall be first used to offset any cost of selling the property, and any liens on the property after paying any liens on the property in full applied to the payment and storage expenses. And then the remaining proceeds shall be distributed as follows. I love this. 45% is distributed to the Office of the Attorney General, the Department of State's Attorneys and Sheriffs, and the state and local law enforcement agencies. And the rest, the 55% goes into the general fund. And the Secretary of Administration, the agency of administration, is the one that determines the distribution of the 45% to the Attorney General, the state's attorneys, or other law enforcement. So I just want to note that this is procedurally difficult. I don't think you're going to see law enforcement exercise this authority often. If they exercise it for a piece of harvesting equipment, it will effectively be a one-time kind of example. Because to go through this process is not easy. And so I just want to note that.
so just thinking about the math too, for a piece of equipment that is, I know we've heard multiple hundreds of thousands of dollars, so say $500,000 piece of equipment. If that is, even if it's owned, but with a large debt, after the debt is paid off, then you're talking about a small fraction of 500,000, which would then be distributed. And so to the extent that law enforcement is thinking about incentives, and I imagine in some cases they're making that calculation, it's not a large amount of money that would necessarily come to them.
And I wouldn't equate this authority to like the local sheriff who gets paid for every speeding ticket they issue, because the time and effort they have to put into doing this, getting the equipment, getting it on a flatbed, finding a place to maintain it, storing it appropriately for that time, going to the court hearings, offering the information necessary to prove that they've been, that is much more time than they're probably, an expense, and they're probably going to be compensated for in the end.
See that there was a section of language there that will be repealed. Is that anything of interest?
So this B1B, it's the eight.
What follows there?
So it would be the agency of administration being the one that distributes or
Okay.
allocates. That is what is slated for repeal on July 1, 2024.
So is somebody else going to be taking that on?
I think I don't know how the distribution is going to go, the 45%. After July 1, 2024, that's probably a question that the judiciary committees are going to have to answer.
Representative Lipsky and then Representative Rice.
Mike, what strikes me is, unless I missed something, the Attorney General's office gets a chunk and the general fund gets a chunk, but the person that's been ravaged, the victim, the landowner, doesn't seem to get any percent. And this seems like a bunch of, misses the mark of the intent.
There is opportunity for victims of crime to receive restitution and in some cases damages for the harm that's been done to them via the crime. I am not even remotely informed on that subject. I want to bring in one of the Judiciary Council to talk to you about how the restitution process works.
The follow-up is that, while we acknowledge that some of the harvesting equipment is mid and high six figures, the reality is the average used 40-year-old skidder is worth between $25,000 and $50,000. So by the time and if there is a lien on it and that's served, and then it gets there isn't a lot of incentive for law enforcement for gain or recompense for their investment.
I wasn't here for the testimony of Megan Harris or Megan Purvey or the commissioner. Did they say anything about the exercise of seizure?
The one thing that did come up was that it would likely be at the state's attorney's level. So, and we may speak to somebody at that, one of those offices.
And I do know the state's attorney but they have prosecuted timber trespass. Rory Thibault, who just ran for attorney general but lost, when he was the state's attorney, he did it. And he was successful in prosecuting, but he didn't seize anything.
Representative Rice?
Yeah, just two quick questions. One is, in the case where if there's a lien on the property and it then is going to be auctioned off, is there a process where there's a minimum set that would pay off that lien, or is there ever a case where it could be auctioned off and the proceeds wouldn't actually pay?
Yeah, there's no, what do they call that in auction?
You don't get the reserve.
The reserve
Yeah.
price. Yeah, I don't think there's a reserve price set here.
And then has there ever been an example of any specific, of another instance of sort of adding the ability to seize property under the statute where the where that distribution has been adjusted so as to incentivize one authority or another to maybe.
No, I mean, the animal cruelty was added as one of, that's an example of adding a non-drug related crime to this seizure authority.
But they didn't, for instance, say, the sheriffs are really don't have the capacity to go after these animal cruelty cases. So we're going to say 100% of the proceeds go to the sheriff's department. So to try to incentivize the
No,
sheriff.
they didn't do it like that, but I think seizure is used for animal cruelty because if seizure isn't used, then the cost of storing animals is basically on the law enforcement agency or on the humane societies that take on the responsibility of caring for the animals that are alleged to be abused. And it can be expensive. And the animals that are seized can be really expensive. There was just these award-winning horses that were just seized and
Yeah, and they're being rehabilitated at the Dorset Equine Rescue. So I'm familiar with it.
yeah.
I think that, I think even with seizure, the cost ends up, much of the cost ends up on the organization.
Right.
Like, I just wondered how, also, I'm unclear how this works where, say there's the $500,000 dollar buncher that's seized. And then United Ag says, well, we're still owing 400,000 on that, and the loggers missed the last, 4 payments. Does the state have a way of just sort of giving back that piece of property to the lien holder, or does it have to go through this whole complicated auction thing where in the end the state of Vermont loses money in the whole deal?
But remember, forfeiture is voluntary. So if they don't want to go to forfeiture proceeding and the lien holder has a claim of that they're the owner, the lien holder can assert ownership and reclaim ownership of that equipment.
It's not a percentage, right? They have some lien on it.
I mean, I would talk to the banks about when they would assert effectively repossession.
In the instance where a third party actually owns the equipment and the existing language that we walked through a minute ago talked about, I don't remember what the wording was, but if they should have known that there was a problem, then they might be liable, but otherwise it wouldn't be. I'm wondering whether our adding of, we're creating this registry or some other way of alerting the public that, this is someone who has done something that puts his name on this list, whether that could be used as justification for saying, oh, you should have known because before you lent your equipment to this person, his name is on the list.
So it was implied knowledge that the property was being or was intended to be used in a manner that would subject the property to forfeiture. Prior violation as the implied knowledge that they were going to then use that equipment for a future perspective. I think you can make that argument. I'm not sure a court would recognize it.
The questions?
Can you just, I think I just probably missed it, the part where that designates who can actually seize something, like it has to be a law enforcement agency.
Yeah, it's a great question because it's not entirely, it doesn't have it's not written in an active voice. So it says the court may issue the ability to seize, but it doesn't reference who they issue that authority to seize to. And then it says any property may be seized without that court order if it's subject to an arrest or valid warrantless search. It doesn't say law enforcement, et cetera. But when you go to your bill, it says the Attorney General or State's Attorney.
And then they're gonna designate, right?
Does it
The
say?
Attorney General or a law enforcement officer may.
John,
What's the discretion of this law enforcement to, as far as what they potentially could seize? I mean, it could be as little as chainsaws, but it could, a one-ton truck that's used in logging, that it also.
So if it's property that was subject. Property that was used in the commission of the alleged trespass. As to law enforcement's discretion, all law enforcement has something called enforcement discretion. That based on the facts in front of them for each individual violation, they can make a determination about what they will enforce or not, and hear what they will seize or not. They have the authority, but they're going to have to go through this whole process that I just outlined to you. Are they going to want to go through this process for a chainsaw? Probably not.
Representative Temple.
A lot of these nefarious loggers have employees. Would the employee property be subject? Such as a truck that they drove to work or even used to pull a log, say,
Again, I think that,
discretion.
if it was, right, if it was property that was used in the commission of the alleged trespass, technically, I think they might have a claim for, or an authority for seizure, just like property used in the distribution of illegal drugs. But they do have that discretion to seize or not. I think if someone said, I was just doing what my boss told me to do, I think law enforcement would probably exercise discretion and not seize that.
You would hope.
I would hope.
Representative Lipsky.
Mike, there's sort of a colloquial notion that possession is 9/10 of the law. You hear that kind of comment. Could a landowner, the skidder's on their property, they haven't gotten the check that they've been promised week after week. Could the landowner, fire that thing up, drive it out behind their barn and park an armed sentinel on it and say, that's my skidder?
Yeah.
I would, I don't know.
I'm not
how to
trying to
answer
be-
this without authorizing a crime. I think if you are going to withhold property that is legally the property of someone else, you potentially could be subject to criminal enforcement. Even if that person owes you money, I don't know of any authority, and there sometimes is authority. If your bull gets loose and runs onto somebody else's land, the landowner can hold it and ask and keep it until you have compensated them for damages and paid your fines.
Hmm.
I mean, that is like literally from like the 1800s, but it's still the law. And your fine is only like $5, but that there is ability. I would think that if that property had a lien on it and the harvester couldn't access it and wasn't able to use it to pay the lien, then you would be in an issue with the lien holder about gaining access to that property.
I just had a question about state lines. Is there anything in this that limits it, just because we are such a border state? Like if someone is a business from another state, is there any restrictions there? Does anything change if the company or the equipment is not in state that you're trying to see.
So if the violation, the crime occurs in Vermont, then the ability to seize the property that was used in Vermont, when it's in Vermont, is present, regardless of whether it originated from New Hampshire, New York, or Massachusetts.
But it has to be in Vermont at the time of seizure.
Yeah, I don't think law enforcement's authority extends to seizure of property that, is in New Hampshire.
Yeah,
I've been told of a number of instances of alleged home improvement fraud that involve bad actors from out of state, and how it adds difficulty.
That's
which
kind of what made me think of it as, that
in home
I've heard
improvement.
that too.
Dave, did you?
Yeah. So given the timing of these sorts of incidences, often the homeowner is alerting the authorities after the fact, after the equipment's been taken off the land. Does law enforcement have the authority to go after and seize properties that are not on the property at the time?
Well, that's where you would go to the court and you would get that order from the court and say this equipment was used in this alleged violation. Here is my proof of that. And then the court issues the order for seizure.
Yeah.
We had a question this morning about, just a question about language that's been added in the draft at the bottom of page 11, like.
Yep.
The words when applicable. And since it is then followed by registered drug, why that's here.
Because if you had not added when applicable, the petition for service of the in the newspapers would have to state the type and quantity of regulated drug involved.
There isn't one.
There isn't one. In
Okay. Good. Makes good sense. John?
So Mike, just going back to Dave's question, if your civil judgment comes 8 years later and the timber trespasser now has all new equipment, is it the equivalent of what was used on the job?
It says the property was used in the commission. So if they have brand new property, I think you wouldn't be looking for seizure. You would be looking for your damages. And again, in that instance, since seizure is discretionary, I doubt you're going to get law enforcement to initiate that.
Other questions? Okay. Was there anything else that, other than seizure, forfeiture, that anybody wanted to ask about now while we have Mike? So thinking about the language in the bill. Okay.
We've heard testimony about some of all the complexities and challenges with seizure. We did receive testimony last week, and I doubt you were necessarily in the room. And it had to do, and it was testimony by Dana Doran, Executive Director of the PLC of the Northeast, how they deal with protections in Maine. And one thing, and as Danny pointed out today, the state of Maine has a giant forest, state forest, service officers. So we're not an equivalent. But if someone is twice convicted of timber fraud, timber theft, they must provide a $500,000 bond, and the contractor must get a release from the State Forest Service to prove that they have posted that $500,000 bond. And they do not, that protection is what in Maine they do in lieu of seizure and forfeiture. And that's his testimony to us implied that that works pretty well. Would you think to have more teeth or protection in this bill, we should be looking at that approach versus seizure to protect?
Bill already requires financial surety or a bond. And that's what the home improvement fraud statute already does. If you are convicted, you are either convicted twice or you're convicted of a major violation. Then you are,
That has all that language in it.
yes, and you are required to post a $50,000 bond with the Attorney General, or you can work for another company, provided that that company is separate from so you're not taking away their livelihood. Like if they're a harvester and they were running a company that was convicted of land improvement or timber trespass, they're convicted and they can't afford the $50,000 bond, they can go work for someone else. As long as there's not like a personal or corporate relationship between that worker. So you're not manipulating some corporate structure to take the person that was the CEO and make them a laborer, and then elevating your 12-year-old daughter to be the CEO, right? And so that is already there. It's $50,000, but it's $50,000 plus you're on that requirement to have that bond for 6 years. And so it's not just you post your bond and you're free to do what you want. You post your bond and you're subject to the AG's oversight for 6 years.
I think that's quite strong and adequate.
I think it's an effective enforcement tool. Whether it could be stronger or not, you probably want to talk to judiciary about that. Whether or not it's viable for anyone to be able, or for some people to be able to get that surety, that letter of credit.
So if it's too high a dollar amount, the cost of getting that surety is excessive, it would begin to impose a burden on everyone that may not be fair. Is that the way you're thinking?
$500,000 to me seems
Got to be a big deal.
you got to be a pretty big company to get that letter of credit or bond for that.
That answers my question. Thanks for, I'm sorry, I'm not so fully aware of the bill.
Okay, thank you, Mike, for that. And wondering, I've been jotting down as we've been going this morning, just other possible people we might want to bring in to hear from, where there were questions that needed somebody else to answer. What do you all think in terms of other testimony who you might want to hear from? Right.
But it just seems like state's attorney keeps being mentioned.
Yeah. So maybe somebody from the Office of State's Attorneys.
Yeah.
Speak to that. Okay. Yep. And
Probably that person would be able to answer it, but I'm curious, and maybe it's just me and I should follow up with somebody on my own time, but just this process of going through, I'd like to run through a process of what actually happens in the court system in a case like this and where it can essentially go awry, like somebody that knows the law and how how this process actually plays out.
So today, is with existing law.
Yeah, yeah, and how this would change that in any way. you know.
John?
If you were gonna ask somebody from the insurance industry about what a $50,000 surety bond costs.
Or lender.
Okay, yeah.
I was just wondering, just to Henry's point, I imagine this bill would go to judiciary after us, so just wondering,
Yeah.
like, how much we need, how much it's sort of imperative on us to dive into that, or how much would sort of be handled, but.
Yeah, I think that I think that's our judgment, and I mean, it's a good question. I think, the more we can do and buttoned up so that we feel comfortable, then I think the better off, more likely it is to, not get closer scrutiny and move along more quickly. But I think we need to think about our own time and our own resources and context of everything else up there, and how deep we want to go into that. But
In addition to Representative Rice's mention of a state's attorney, strikes me after hearing all this testimony and landowners that would it be appropriate to invite a sheriff in or a police chief in to see? Because if I were a landowner, I wouldn't necessarily go in my phone book, try to figure out how to reach the state's attorney, but if I called 911 and for the Lamoille County Sheriff, I'd get a dispatcher and a live voice. And, what we've heard is that's not our purview, and that's.
yeah, no, I think that's.
Would it be relevant to talk to someone in actual law enforcement?
Yes, I think it would be somebody who can speak to that. Yeah, if not a sheriff, just somebody who can
Right.
talk to it. But
But could we not potentially sort of knock both of those out with the sheriffs and state's attorneys are one?
they're one
office,
association. Yeah. We might start there. Yeah. Good. And then we had a little bit of a conversation around educating landowners so that it never gets to the point where equipment needs to be seized or someone is seeking, redress. So I know, Josie, you were interested in that. If there's a thought that maybe there's something in this piece of legislation that we can do, if you want to give that some more thought and see who might we want to talk to about, maybe we can talk about that offline, but okay. Good. Anything else? All right. Well, thank you, everybody. Thank you to the witnesses. We did have, actually, there was a question maybe you wanted to ask Chris to come back for. I'd forgotten about that. I'd forgotten what the question was.
UCC.
I want to have a conversation if he's willing to take the seat. Maybe we could ask him about
Okay.
that process.
Yeah,
We got 2 more.
I know somebody's got it. We do have 2 minutes and then we need to stop. Welcome back.
For the record, Chris Delia, UCC filing, put it in the context of what type of equipment we're talking about. If it's something that would meet the definition of a motor vehicle, that lien gets to the Department of Motor Vehicle. If it's non-motor vehicle related, that lien gets filed with the Secretary of State's office under a UCC filing. It's a searchable database that anybody can go in and take a look at. To your question on payments aren't being made to the lien holder, how long do you wait? It's at the discretion of the financial institution because they don't want to have the equipment sitting on their property, quite honestly, because then they've got the responsibility of moving it. So they'll work with the borrower to try and figure out, do we need a payment plan? What's going on here? At some point, they'll make the decision if it's not working for the institution's best interest and repayment's not happening, that they'll have to seize the equipment. But that's further down the road because similar in seizure. It's where they're going to park a skidder on a bank parking lot, and I guess, but UCC filings, motor vehicle filings, very easy to take a look at.
So motorized skidder is not a motor vehicle.
I don't want to go into what the definitions may be. You'd have to look under transportation definitions in statute, but if you're buying the dump truck that's pulling the logs or the log vehicle, maybe that is considered under statute something that is under the motor vehicle statutes by definition, which in that case, you're going to see a lien over a DMV versus a skidder, which may not fall under that definition, which would be UCC filing at the Secretary of State's office. But that's, in general, that's how you perfect your interest. You file a UCC with the Secretary of State's office or a lien on a motor vehicle. Seizure under the drug statutes very quickly, typically seizure of a motor vehicle, if it's involved in drug statutes, much easier to do. Sometimes there's discussions about seizure of a piece of property, a home typically, because maybe the drugs were being produced there. Very different discussion than what you're having here.
So lien holder seizure is a whole different part of state statute, I take it, than what we're talking here of drugs or animal cruelty seizure.
Yeah, I mean, liens are definitely in Title VIII. There's some sections of Title IX consumer protections that might have liens associated with it. But the seizure piece, if that were to ever get triggered, is under the statute that Ledge Council was talking about. I'm not aware of a separate seizure statute.
Thank you.
Thank you.
We're